Alex here with a high conflict child custody video on Repzion's, I guess we call it Repzion's Vengeful X. I do want to make a disclaimer right now that these are just accusations by the other YouTuber, and so without knowing anything more than what he's provided in his most recent video, which I'll play a clip of now.
She's admitted to strangling me and attempting to kill me. She's on the record, on audio, threatened to take my life, that she wants to bash my skull in. I got out of a domestic violence relationship successfully, and she continues to harass me and try to do everything in her power to disrupt my life. I'm in a different place in my life. I am happy. I've been in constant therapy for over 8 months now, almost every single week. Going through coping with all this trauma. I don't like saying this shit because it's... Look, I got an ego. Everybody has an ego, but I have been going through so much stuff recently on trying to get through all the trauma that this woman caused me.
Yeah, as I mentioned in this, I get more information. I'm not going to really go into my opinion as to whether any of this has any merits. The only thing that I will do is I will analyze the two filings that he posted, because that's what my viewers asked me to do. And as I've done with my previous, I guess you'd call them reviews of other people's cases, the last time I did one was for Tech Lead. I'm not going to really go into the nitty gritty of any of these because I'm not sure that the wider audience of YouTube is really that interested in them. I know you guys are interested in them. So if the channel ever gets like 100,000 subscribers, I'll do this stuff more often. But from what I've seen, this stuff kind of gets into the weeds. So yeah, let's go ahead and open up. By the way, I do want to mention that clip that I posted, I did find to be authentic. So even though I won't go into my sort of personal opinion as to the merits of any of the litigation, I will say that my personal opinion of that clip is that this is authentically a male victim of domestic violence. I do find his emotional, I guess you could say, testimony to us, the public, to be credible. I believe it. So let's go to the actual documents that he provided. The first is a motion for reconsideration to vacate a protective order. I've never seen this before, so you guys are going to see my real-time reaction. And it's interesting how they do this. What state is this? Washington? So in the upper left-hand corner, usually you'll see the author of the paper. And in this case, it has the judge's name. It might be because it includes an order at the bottom. So the attorney, I guess, put a stamp at the lower right-hand corner here, Adamant Law Firm. This is a Washington attorney, so I don't know anything about this guy. Standard introductory paragraph. Moving the court to vacate and reconsider a 5-year protective... Well, wow, that's a lot. So Nevada only has 1-year protective orders. Unless the law has changed, that's the highest you can get. I've always thought that there were situations in this state that warranted a 5-year or even a lifetime protection order. Most of the time, I do not think that that is necessary, but there are examples that I have seen where it does make sense to me. Even a lifetime protection order. I could count on one hand how many I have seen that would warrant that, but I have seen that. And it's, these people are obsessive. So let's continue on. No basis for the motion. No jurisdiction over the matter. Improper venue. So jurisdiction would mean that the forum is improper or inconvenient, and we're talking the state itself. Venue would mean that it's the wrong county. At least that's how we do it in Nevada. Or it could be more specifically, you could have filed the case in the wrong district court or the wrong justice court. I'm not sure if when he's talking about no connection to the county, he's talking about personal jurisdiction / venue. Neither of them lives in the county. None of the purported incidents complained of occurred there. Petitioner lives in Portland, Multnomah County, Oregon, and she filed a petition against him. And Daniel's in Multnomah County. So they're both in Multnomah County. So he's bringing up that she attempted this in Multnomah Superior Court, which dismissed both petitions sua sponte, which means without a motion from Repzion, and that she withheld that information from this court. Yeah, that is indicative of an abusive process, and I think that's what we're going into with the second filing. Um, because had she notified the court, res judicata principles would have probably been considered. If you want to know what I'm talking about, please watch my legal nuts and bolts video on res judicata. Um, Despite Multnomah Superior Court's dismissal of the petitions, she filed a nearly identical one in Clark County, a classic form. Okay, so yeah, not only would this be potentially abusive process, but if she does this enough, they may declare her a vexatious litigant. That's what they would do in Nevada. And that would block her ability to file these types of lawsuits. She would lose her constitutional right to file lawsuits. What's probably going on, and this is just speculation based on the little that I've read so far, is that this individual, Repzion, is trying to ignore his ex, and she doesn't like being ignored. And so one of the things that people like her will do when they're ignored and they don't like it is they will start filing lawsuits because they know you cannot ignore lawsuits. Or they will do that to disparage you. So, I mean, that's more done so in the sense of not, that's what I was about to say, not serving. So a lot of these situations, somebody will want to disparage somebody and they'll file a lawsuit without serving them, or they'll lie on the service of process. And then once the default order is entered, then they will say, hey, look, this person is blah, 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 as I've been saying, because I have this order from this court, and it gives this sense of legitimacy that normally they wouldn't have. And that's a lot of the people, the general public doesn't really know these tactics. They don't know about abusive litigation practices. And so when somebody has a court order and they wave it around, it's very believable to an ordinary person who really doesn't understand that this stuff can be procured through abusive litigation practices. So improper service was what I was about to talk about, and here it is. He's saying he was never served by the petition. He wasn't present at the hearing. The 5-year order against him is entered by default. Her petition seeks an immediate weapon surrender. Well, that's another thing that sometimes people like this will do, is they'll try to mess with you by taking away your Second Amendment rights. Court's May 18 denial order did not allow for alternative service. According to a proof return of services, the sheriff emailed a copy of the petition and denial order. Interesting. I understand what they're talking about. So what do they call it? A substitute? What do they call it? Hold on. Alternative service. Yeah, typically alternative service is allowed by statute and by court rule in very specific circumstances. Most of the time, judges and courts do not like it. When you initiate a case, what they expect is personal service. But there are all sorts of oddball ways to get around that. And as far as I know, you have to get permission from a court to do that. One example I can think of in Nevada is if you try and serve somebody who lives in a gated community. Now, if the gated community does not allow for access, you can get permission from the court to mail it to them. And you still have to get permission. And if they have an armed guard, you can leave it with the armed guard. I don't believe you need to get permission for that. But what I will say is that probably the reason you don't have to get permission is because you're leaving the lawsuit with a living human being who's over the age of 18 and who, I mean, it's his job. He works there. I don't know if it has to be an armed guard. It might just have to be a guard, an actual guard. Anyway, this is what he's talking about. And he's saying that she didn't get permission, and therefore that service is invalid. Now, I notice here that he doesn't specifically mention whether or not he actually received that, which makes me think that he did, and that he probably consulted with an attorney who told him he didn't have to respond since it was invalid service. This happens. People will get notice of a lawsuit and then they won't respond because of advice that they get. I don't know how I feel about that, guys. I know that the allegation here is that his ex is playing games, and kind of what lawyers will do in this case is fight fire with fire. Hey, if she's going to play games, we should play games too. But I'm not sure that this is a great way to go, because then the default gets entered and then you have to kind of do all this work to fix it. And it also can be used against you publicly, and it's not good since he's a YouTuber. So if I was, service of process is not a game. I did a video on it. Watch the video. I mean, there's consequences. I know that it's not fair that they didn't follow the rules. I know that it's not fair that they got something by not following the rules, but eventually it's going to have an impact on your life, and eventually you're going to have to do all this work to fix it. So in my personal opinion, what I do if I find out a lawsuit's been filed against me is I deal with it, even if I've not been served properly. It's just it's and it depends. It's just, I know it doesn't sound good, guys, but you have to see this thing all the way to the end. And if you watch this guy's video, you'll see that he still had to do stuff to fix it. He still had to hire an attorney. He still had to pay attorney fees. So even though he wasn't served properly, it wasn't just, I mean, the judges are not psychic. They don't know what they don't know. So yeah, he cites the rule, well, this could be a statute, that mandates that personal service is compulsory when protection orders require the surrender or prohibition of weapons. Well, that makes a lot of sense because that's a constitutional right. So yeah, that makes a lot of sense. Single email from the sheriff which went unanswered is not sufficient service. Then they also have to show verification of notice of electronic service. The verification must include a sworn statement and a follow-up, which makes sense. I mean, you want the person serving to swear under oath that they did serve. We've had issues in Clark County of process servers lying about serving people. Follow-up communication by the respondent is required. The proof of service provides no follow-up communication with the respondent. Petition includes a surrender weapon request. Then electronic service was improper, and even if it was proper, it was improperly effectuated. This is a good basis to set aside this order. No basis at all for the protection of order. None of the claims rise to a level of requiring a protective order. Exhibits were intentionally cropped. Dates removed were ineligible. She makes claims that aren't true. So these are factual assertions that would be controverted by the other party. They would require evidentiary support. And from what I listened to in his video, there was a hearing and it was less than 5 minutes long, and the judge, so that makes me, if it was that short, it makes me think that his ex never showed, which is pretty consistent with what happened in my case. If you watch the My Docket series and you see the writ petition that I filed and the Supreme Court of Nevada's response creating a procedure for me to challenge my ex's allegations, once I challenge her allegations and she has a hearing date and time to show up and assert those allegations, she doesn't show, which is another thing that's consistent with a lot of these purported victims of domestic violence, is they'll make allegations that they don't have to prove, and then they'll get ex parte relief. And then once they get ex parte relief, if it's challenged and the second hearing is set and they actually have to deal with proving what they've said and they actually have to deal with cross-examination on the stand, then all of a sudden they don't want to go. And so very similar to what happened in my case, I would assume that a very short hearing, less than 5 minutes long, does not have testimony being submitted to the court. If there's no testimony being submitted, either his ex showed up and wasn't able to get past the first hurdle, which is the threshold question on service of process, or his ex didn't show. Because all of these, I mean, he's basically denying all of her allegations. She brings up, I like that this gets brought up, ex-girlfriend to current girlfriend to court, story time. Constitutionally protected free speech, which it is. It is free speech. And the judges in family court need to get over this. They need to get over it. Luckily, it doesn't sound like this, well, maybe it did. Maybe this did go to a family court judge. I don't know. Entitling a YouTube video message to my ex-girlfriend and discussing the facts of the abuse, constitutionally protected free speech. Yes. Absolutely. Petitioner claimed, again, this would have gone to an evidentiary hearing to determine to what extent it was free speech and to what extent it was abusive, but never went to an evidentiary hearing. And there's a reason why. We just don't know what the reason is. Petitioner claims Daniel didn't log out of email. I love this. Okay, yes, you shouldn't do that. That is bad. But the best thing that you probably should do if you're claiming that you're being abused is change all your passwords. So yes, a person should not use your password to hack into your stuff, but you also have, a sort of expectation from the public and the court to change your passwords. So he's saying he's denying this allegation. And when I see stuff like this, it's annoying to me Okay, don't do that. It could be used as a basis against you, but at the same time, anybody who has an evil X would know to go and change all their passwords. It's just like an obvious thing to do. And so when you don't do that, it makes your testimony that you have an evil X incredible. Petitioner claims that Daniel made fun of her body. How is that? Daniel did not do so. Petitioner claims that Daniel's girlfriend published statements about her online. What a third party may or may not have done is, yeah, that's true too. Claims a false claim that a year ago, after an unsuccessful petition, that they yelled profanity at her from a car. That doesn't, okay, so yeah, profanity is not harassment. You have to feel like, in Nevada, it requires a feeling, a threat that has to do with bodily harm or killing you, stuff like that. I don't know if I think they have a different thing for harassment on social media. I'm not entirely sure about that though. Petitioner falsely claims that Daniel hired 5 PIs, only 2 being licensed. He hired 1 private investigator to effectuate personal service of a defamation lawsuit. That's it. Clark County is the improper venue, has no jurisdiction, improperly served, no substantive basis for the order. Statement of facts supporting reconsideration. So looks like he's arguing that she has a motive to manipulate, deceive, and abuse the court system, and that there are declarations in support of that motive. Dating relationship, they lived together, that she physically abused him, that she on multiple occasions admits it, that she emotionally abused him, that she assaulted him, captured on camera, that he was able to safely leave the relationship, entered a new relationship. Smear and defamation campaign. I really like that more YouTubers are talking about this, because I think that people don't understand the insanity of family court and restraining orders, and I think that I'm just really happy that more YouTubers are talking about it. Doesn't necessarily mean that I agree with the YouTuber. I just agree with the fact that I think tens of thousands or hundreds of thousands or millions of people should know about it. And I think that the concern is more so with the process than, for me anyway, it's more the process and people becoming familiar with these tactics than it is who's right and who's wrong, which I know from their perspective, that's what it's about. Hey, this is what my ex is doing. Please believe me. I understand that. But from my perspective, I'm happy to see more people learning about abusive process, abusive litigation practices, high conflict child custody situations, restraining order situations, and the competence of the family courts in all 50 states, not just Nevada. So she's published over 5,000 defamatory statements about him, that she admits that she defames him, and she frames him as an abuser to get more customers on OnlyFans. That's so messed up. And it's like, if this is true, in my opinion, it's self-destructive on her part, if it's true. That this is a very self-destructive approach to making a living, if it's true. That she works with a team of conspirators to make false reports about him. That she's trying to report to DCFS to get the kids taken away. That the Child Protective Services was forced to investigate and determine that the claims were unfounded. Well, this is actually, he could recover significant funds from this for intentional infliction of emotional distress. If he can prove it, which a lot of times this is provable. She's dodging process of service, which is typical with an abuser. She's filing anti-harassment petitions against him. She's claiming that... oh my God, that's right out of the playbook, guys. That's what happened in my case. That is... I mean, she's checking the boxes. Checking the boxes. So if this is true, this is a common tactic from an abuser is they will claim that your efforts to serve process on them counts as harassment. That's exactly what my ex did. It's laughable, but in their mind, I don't understand what they're thinking sometimes. Watch my video on the topic, your ex's motives. Filed for bankruptcy to stay the lawsuit. Hold on. What does he mean by that? What? Oh, she filed for bankruptcy to stay the lawsuit, which she can't do. Which somebody probably advised her to do. Which, okay, guys, let's talk about this. This is something that people who are thoroughly, I guess you could say, educated on abusive litigation practices will do. They will do things like they will defame you a bunch of times, they'll damage you civilly, and rack up hundreds of thousands of dollars and millions of dollars in damages. I have seen this before. Usually lawyers do this. Usually not good lawyers. Usually disbarred lawyers or disgraced lawyers who don't have a reputation. They will do this out of revenge to somebody, and then when they finally get hit with the lawsuit, they'll declare bankruptcy. Usually they wait until they lose the lawsuit. What she's doing is, it's kind of showing her to be a noob if this is what she's actually doing. But most people who are, they have experience in this, they will wait until the last possible moment to file the bankruptcy, especially after you've won, because sometimes they just want to wait and see, maybe they can win the lawsuit and then they don't have to do it. But yeah, that's not a shock to me that that's going on. I also think that this is self-destructive as well. I think a lot of times people will be like, hey, you're not going to get any money from me. But really, like, dude, you have a bankruptcy on your record now. So, I mean, it might be funny to you that you inflicted all this damage on somebody and you didn't have to pay. But, like, now you got a bankruptcy on your record. That's not something to be proud of. Let's continue on. If this case was in Nevada, I would file a media request. I totally would. Ms. Moore actively dodges service of process. This is mostly relevant if you're trying to get what's it called? A permission to serve by publication. If you want to know more about that, guys, watch my video on the topic service by publication. Barristers. Do they really call them that in Washington? Barrister support emailed Ms. Moore requesting she pick up the lawsuit. It's probably a company. What is this? Hold on. Mr. Rash emailed the lawsuit to Ms. Moore with a request for pickup, who responded with what he described as, quote, ramblings of someone in need of mental health care, unquote. Well, that's the type of person who does stuff like this. Daniel and Jane then hired the civil process unit to serve her. The sheriff's office emailed her. She ignored those emails. Of course she will. And that's another thing, guys. A regular person, when they get stuff from the sheriff's office, I mean, yeah, you can ignore them, but a regular person's going to feel some sense of intimidation from that. Somebody who's well-versed in abusive litigation practices will understand that the sheriff's department won't really do anything to them, and they'll ignore them. These are the same types of people who will ignore the door when the police knock on it. I'm not saying that it's everyone that does that. I'm just saying that this is consistent with that type of conduct. She continues to refuse to receive service. She filed multiple anti-harassment orders, or she resigns. Petition for restraining order was again dismissed, or is this the first time it was dismissed? Failure to establish. So yeah, if you file a request for a restraining order, what we call a Nevada Domestic Violence Protective Order, if you file that and it's dismissed right out of the gate, usually, or I guess always, if it's done properly, it's because the allegations that were made are not consistent with domestic violence or harassment. So she probably made a bunch of allegations that, even if true, would not warrant relief, and that's why it was thrown out. Yeah, it's not a good idea to omit when you refile something in another jurisdiction or venue. You want to cover your butt, and you want to be open about that. You don't have to, but you want to, because you don't want the other person to say, hey, they're abusing process. Because if he tries to say that, you can say, well, no, I was honest to this judge. I told him I told him it was dismissed by this other judge. And my assertion is that I filed it in the wrong county and this is the correct county. But when you leave it out like that, you open yourself up to them saying you're abusing process. Which in this case, it seems like she legitimately is abusing process. She filed a bankruptcy stay. She admits to using bankruptcy for the purpose of protecting herself from these creditors. But she sought to dismiss the bankruptcy when she learned that it would not provide immunity against the law. That's hilarious. That's hilarious because that does happen. That absolutely does happen. People will file bankruptcy thinking it's going to thwart the civil damage that they've inflicted on somebody else. And then when they find out it's not going to thwart that, they're like, well, I'm not bankrupt. Never mind. I take it back. So she's in hot water, guys, if this is true. What does this say? Survey of her petition evinces that it's based on statements made online, which are all protected speech. No jurisdiction over the parties anyway. I mean, that's the basis the court's going to go with. I mean, that's how something gets dismissed in 5 minutes or less. I mean, the judge is probably not going into any of this. The judge probably just goes into the failure to serve. So, what is there a lie about where somebody lives? Ooh, that's not good. I mean, the perjury probably won't be prosecuted, but the abusive process and the vexatious litigant stuff, I mean, you can use that. If somebody's lying about where they live to forum shop, most of the time perjury is not going to happen, but there's other ways that you can use it against them. Watch my video on the topic perjury if you guys haven't seen it. Yeah, they're going to see inconsistencies. So there's a snippet here out of a transcript. What is that from? Oh, you know what? I bet that this is from the bankruptcy court. So not properly served. Yeah, he brings that up. Most of this is just controversion of the allegations that she's made. Yeah, I mean, he's just controverting all of her allegations. He's saying he logged out of her accounts. She has a significant online presence and posts information of herself. She's basically made herself a public figure, is what he's saying, I guess. I don't know. Odd allegations of being assaulted. So they're just using her admissions against her, which is good. You want to do that. Yeah. Yeah, the OnlyFans thing is, it's gonna, I mean, she's trying to make an allegation that he's been releasing photos of her that are like inappropriate. But he makes a good point. It's like, first he denies it, but then he says, how could you possibly tell if a person has gone on the internet and posted their own photos of themselves like that? It creates a situation where, number one, how can you really tell that it came out from, I guess it's some sort of harassment versus you just putting it out on your own? And how can you prove damages? Proving damages is even harder. Because when you prove damages, you're trying to show like, look, this is something that I've never ever wanted, and this person caused it to occur by their publications. But the other side, in this case of an OnlyFans, the other side's going to say, dude, you published like 55 of your own photos. So this other photo, how is that any worse or different from the other 55 photos? How are you harmed in the sense of privacy? It's a good point made by the attorney. the private investigator thing is odd. The video is not monetized. I don't know why it would matter if it was. Scrolling. I mean, these are pretty serious allegations that she's making, and I mean, they can be used against her, and it looks like that's what he's doing with his civil lawsuit. I guess he sued her for defamation. That's the other document. Oh, I've seen this before by defamers. So what somebody will claim, I don't even know, sometimes they don't even claim that you're being defamed. They just don't want a video up. Sometimes you'll put something up that makes somebody look bad. And so then what they will do is they'll put something up that's defamatory. Now, you're not doing anything wrong. What you're doing, what you're publishing is within the boundaries of the law. There's nothing wrong with it, but they don't care. It hurts their image. It hurts them. And so they want it gone. And so what they'll do is they will do something illegal because there's nothing about you that they can publish that's going to harm you. So they'll just break the law and defame you. And then they'll say, "Hey, let's trade. I'll take down my defamatory thing if you take down your matter of public interest." And then we're just even Steven, and we just walk away. I've seen this done before many a time. And a lot of times it comes from somebody who's a loser, somebody they don't have anything to their name, and they don't feel like taking them to court is scary, which is kind of the vibe that I get here. Somebody who has nothing to lose is more likely to use tactics like these, because then if they get in trouble, they don't have anything to lose anyway. That's the thing. It's like a lot of times people who haven't been through a situation like this, they don't understand how this can happen, because they're like, well, hold on a second. If somebody's doing bad things to you, you can sue them. What a lot of people in the general public don't understand is there's a lot of bad people out there who have nothing to lose. And so, yeah, you can sue them, but they don't care. And if you do sue them, most of the time, it's exciting and fun for them. I mean, if you're dealing with people who are harassing and annoying you and making fun of you, suing them just allows them to have more fun with you now in a court of law. And now they're defending themselves, so it's harder for you to say that they're the one that's the problem in the sense of abusive litigation practices, because they're on the defensive, they're not on the offensive. So they can go to the judge and be like, they're the one that sued me, they're the one that started this all, when really they didn't start it. Sorry, when really you didn't start it, they started it by doing things outside of court that triggered the lawsuit. But it's just, they have a field day with being sued. A lot of these messed up people love being sued. It's fun for them. Statement of issues. This is interesting. Usually you'll see this in an appeal. Evidence relied upon. Argument. So it's going to go into the points of law now. The default judgments are generally disfavored across the country, and they explain why. Most courts want matters to be heard on their merits. So he's exploiting the fact that she got a ruling by default rather than on the merits, which supports his efforts to have it set aside. Lack of jurisdiction. So same thing that I've been talking about throughout the video, and it looks like it's personal jurisdiction that they're going for. Basically, where do people live? They're saying that nobody lives there. Blatantly false. Does not reside and has never resided there. Not properly served. None of the petition's claims amount to harassment. So this is a failure to state a claim argument. They're saying that all the allegations that she's made, even if true, yeah, assuming at arguendo that the allegations are true, yeah, the lawyer's doing a pretty good job so far. I haven't seen anything bad. Here's the free speech stuff. I was waiting to see if there were any points and authorities on it. It looks like, what is this? ACLU versus Reno. I wonder if that's Reno, Nevada. If it is, that's pretty cool to see that there. First Amendment protections because the internet is a, quote, dynamic, multifaceted category of communication that includes not only traditional print and news services, but also audio, video, and still images, as well as interactive real-time dialogue. It's very nice to see them. I mean, this is a nice case. This lawyer did an amazing job. This lawyer was very effective and competent, in my opinion, just based on my review of this filing. Really, going into the constitutional analysis is important because a lot of family court lawyers do not understand it and would skip over it or neglect it, or they would point to it incorrectly. But this guy did a good job. I mean, I haven't investigated these cases, guys. So, I mean, you could look up these cases and find out they're off point. But I'm assuming that these cases that he's citing are on point. I also don't know if this guy is a family court lawyer or a civil lawyer. So, for all I know, he's not even a family court lawyer. And this is just something that he was just very good at doing just because he understands civil law. I think that's everything. Yeah, that's everything. You know, guys, I was going to go ahead and do the second paper, but this was a lot longer than I thought. The second one, it looks like it's even longer. So I'm not going to do that today. I'm going to go ahead and do this next week as a part 2. So if you guys have any questions, feel free to post them down in the comments below. And I will see you guys next time.